I'm going to talk about legislation and cases of interest quickly, and then I'll take a break. Brent Wills will come in, and then I'll finish up with some other matters. So first of all, I'm going to talk about health legislation. This is stuff passed by our legislature. If you didn't hear, Chris said they're coming back into session. It looks like at least twice more before the end of the year. So we could see quite a bit of more legislation coming in with changes. He talked about immunizations from flu shots and from the COVID vaccine. Well, what exactly does that mean? He mentioned there was a bill that was passed. This was a piece of legislation that the Hospital Association worked with the business community and with the Nursing Home Association to get information and protections that everybody wanted. And when you have a large group of people like that wanting different things, what comes out in the end doesn't necessarily isn't what you start with. But considering what we started with, it did pretty good. There's some immunity for the COVID pandemic for you all, for situations where someone thinks they or believes they've gotten COVID because they came to your hospital, they were mistreated after they got COVID and came to your hospital. There's protections there. It supposedly will provide immunity for negligence, which negligence normally is not protected. And most malpractice cases, lawsuits, are for negligence. So there hopefully will be protections in those situations. A rather controversial part of it was that it gave retroactive protection. That is, it did not come in till, if I recall correctly, June, but it gave protection under the act back to the beginning of the pandemic, back in March of 2020. Medical examiners, Chris mentioned them several times. There have been some changes. They're allowing easier licensure of physicians coming into the state again. Well, they've also added some additional protections. Here's a bill y'all probably all know quite about already. It's Act number 129, and that is discharge data from hospital is going to have to be reported to the Alabama Department of Public Health through the Alabama Hospital Association. Of course, the timeline when the bill was written seemed, oh yes, we've got plenty of time. It did not anticipate that we would have a resurgence of the pandemic. So the timeline, we may run up some difficulties. Y'all are supposed to start reporting come April 1 of next year. One of the things the Act does provide is provides for confidentiality and privilege protections for the information that you do report to public health. Act 160, and this, we've seen several pieces of legislation passed by the legislature after the orders by the governor and some other stuff. And if you recall, the governor's orders basically shut down the state for a period of time. Well, this new law provides that a business or a church could not be totally forced to shut its doors. Well, Act 188. I know that I have gained some weight during the pandemic. There's called the COVID-20. Some people call it, well, there's a new bill that if you need to get some alcohol, you can get it a little easier. It can be delivered to you. Another important act passed by the legislature, the sweet potato is now the Alabama state vegetable. Important things that come along. This was I think this bill was a pretty good bill, an Act 236. This act puts a cap on how much a patient has to pay with insurance or without insurance for a 30-day supply of insulin. If you were keeping up, insulin costs were going out the roof for a while. The Alabama Uniform Concealed Carry Act was amended. make it a little bit easier to carry a concealed weapon, but there were some good parts to it too. And two of those were that now when someone is arrested, some information is going to be put into that law so law enforcement can check it. And when somebody is committed to the Alabama Department of Mental Health, that information will go into a database and is supposed to be checked when somebody applies for a concealed permit. Act 275 amends the Board of Nursing laws and is going to establish some standards for student nurses, probably will allow some student nurses to do more than they have done in the past. And probably more important than that, recognizing something called a certified medication assistant. And those people are going to be allowed to do, as long as they're being overseen by a nurse, to administer and provide some medications to individuals. Expungement. Our legislature, on the one hand, is very conservative. On the other hand, sometimes it's not so conservative. Every year for the last 10 years, there have been so-called expungement bills introduced. And what these are about is when someone has been either arrested and charged with a crime, or probably more important for you all, has been convicted of a crime, at least in some limited situations. If they go through an application process, they can have a record of that conviction erased from their record. So that's going to make it a little more difficult for you all, for new employees, and checking on convictions of some of the things that may happen. And there will more than likely be more pieces of legislation like that one coming along. Chris mentioned the Community Paramedicine Program Act. This was a very long time coming, a very worthwhile piece of legislation. Hopefully they'll have the rules and regulations published before too long, so everyone will know what the EMS individual can do outside of the pre-hospital program, which in the past they've only been allowed to do. Licensed nurses are going to be allowed to delegate some tasks to unlicensed nurses in certain situations, particularly in community health settings, probably more like assisted living in some other places. But again, this will allow nurses to delegate some duties to non-nurses in regards to medication oversight. Notary public, here's one that's going to allow notarizations are going to be allowed to occur remotely. There's some discussion going on as exactly what that means, so we'll see. For instance, could an individual be in Georgia and the notary be in Alabama, and that occur and be legal? We don't have an answer quite yet on that one. Act number 341 has to do with limitations on pharmacy benefit managers. There's been a lot of discussion about pharmacy benefit managers and the amount of money they seem to, at least according to a lot of people, siphon off from the system that otherwise might go to a provider, such as a pharmacy, or might go to a hospital. And the money is going, at least supposedly, to the pharmacy benefit managers. Well, after passage of this law, it should be a little more difficult for that to occur. The Alabama Department of Insurance already licenses these companies, and they will have stronger licensing regulatory authority in the future. Alabama has a hospital lien law. Alabama used to have one of the strongest hospital lien laws in the country. Well, that has been amended over time, and unfortunately it has been amended again. The old law allowed the hospital to have a contract with an insurance company to do what you wanted to do in regards to hospital liens. Well, this new law says you can't contract that away. Board of Nursing, access. Board of Nursing is going to get access to controlled substance database. As you might guess, there are a whole lot of nurses in Alabama. When there are a whole lot of nurses or any kind of healthcare providers, there's a potential for abuse of pain medications in particular. And the Board of Nursing, when they're having a licensure investigation of a nurse, will be able to access the PDMP, it's so-called. This is kind of interesting to me that y'all know what a community mental health center is. Community mental health centers are analogous or similar to healthcare authorities. They have their own special legislation where they are created as a quasi-governmental entity. Well, under this new law, they are going to have the same immunities which are currently provided to state employees. I dare say that will be tested fairly quickly. This is another medical marijuana bill, allowing more use of medical marijuana in Alabama. This is the visitation bill. I think Chris mentioned it during his presentation. The Hospital Association, I know, and the Nursing Home Association worked with the Alabama legislature, fortunately, and they were willing to listen, maybe grudgingly, but they were willing to listen to the particular idea that hospitals, nursing homes, and other providers have federal laws that you all have to deal with. And sometimes it doesn't matter what the Alabama law says about what you have to do. Again, they grudgingly in this law recognize that there are situations where you will have to pay attention to what the federal government says you have to do in regards to visitation. Yesterday, I had the pleasure of meeting my new physician. My prior physician of 35 years retired. I guess if you live long enough, your doctor retires before you do. And I felt a little bit like this fellow when I was telling him all of my problems yesterday. It took a while. Sexual assault survivors. There's been a lot of problems over time in Alabama with people having been sexually assaulted and the problems they encounter when they come to a hospital emergency room. And there have been these kits that have been developed. At one time, I think there were several hundred, maybe even several thousand sexual assault kits. That's where evidence is gathered that were sitting somewhere and had never been used. So some of this will speed up that process. Chris mentioned the vaccine passport law. This law is just frankly written terribly. I don't know what it was intended to do. You can't tell from reading it what it was intended to do. And when you have a law like this, it's difficult to tell you all what is permitted and what isn't. So we will see more from this. It seems to be clear, at least on one thing. If you're a private hospital, it does not apply to you as far as your employment practices in regards to COVID immunization requirements. Now, obviously, we're going to hear more from the federal government in regards to that. We talked about that. Driver's licenses, we've seen some laws about that. We've seen some more. Let's see, do not attempt resuscitation. This was, we've had many changes over the years. Do not attempt resuscitation. We changed the law, the legislature, we didn't change it, but the legislature changed the law to allow for minors, and at least in some situations, to have a do not attempt resuscitation. This year, this law changed, so it is very clear that when you have a minor and you're going to have a do not attempt resuscitation, you have to get the parents involved in that process. And myself personally, as a parent, I want to be involved in that process if and when it comes to that. All right. Again, this felt a little bit like I felt yesterday when I saw my doctor, my new doctor, for the first time. by the way, who was only about 35 years old, less than half as old as I am, I guess. Cases of interest. Good news, bad news. Good news is with medical malpractice cases, it continues to be very, very tough for plaintiffs to win cases against physicians and hospitals. The tort law has a provision that says if you are going to be accused of committing malpractice, and you have been accused, you have to prove and show what the malpractice was, which means you have to show what the practice was. You or I, as lay people, cannot tell a jury what that is. You have to have an expert. Well, that expert has to meet certain requirements under Alabama law. They have to be similarly situated, and they have to be practicing in the same specialty as the physician, if you're talking about that, or if you're talking about a nurse or otherwise, to testify as to what that individual should have done. Well, in most of these cases, and I'm going to go through them quite quickly, the hospitals have been able to get out of, now it took a while, had to go to the Alabama Supreme Court to do it, but had been able to get out of those cases even when the jury had come back and returned a verdict against the hospital. Sometimes just getting something delayed is a win, particularly in certificate of need law, but sometimes getting a delay right now until we find out what the federal government is going to do in regards to vaccine mandates and other stuff might be a win. This next case, here's a situation where a $100,000 verdict was returned against the hospital. They appealed it, and the Alabama Supreme Court overturned that. And they said the plaintiff failed to show what the standard of care was in this situation. And so if they didn't show what the standard of care was, they could not show there was a breach. We'll go quickly. Oh, this is kind of an interesting case to me as a lawyer. This was not a medical malpractice case. OHG of Enterprise had a hospitalist who was friends with a local attorney in Enterprise, Alabama. Their children went to the same school. So the attorney had a divorce case and had heard some things about one of the parents and went to the doctor at the hospital, and the doctor used the hospital computer and checked information about one of the parents, the PDEMP. And remember, I talked about that a little earlier, and some other information. The parent obviously did not know this information was being obtained. The hospital did not know and did not excuse or allow this kind of stuff to happen. Anyway, they went through a long process. The attorney settled, the doctor settled, and they wanted to sue the hospital. And again, fortunately, the court ruled that since the hospital had no knowledge, would not have allowed this. Had it known knowledge, then they could not hold the hospital liable for a breach of HIPAA under, as well as state law. Let's see. A lot of y'all put arbitration clauses in your agreements that you have, from computer contracts to employment contracts to all sorts of stuff. The more I practice law, the less I like arbitration agreements, and the less likely I am, frankly, to advise my clients, at least, to put them in there. And one of the reasons is a case like this was a accounting firm that hired an individual and had a mandatory arbitration clause, but it was vague. The individual sought to take the accounting firm to court. The accounting firm says, no, we have to go to arbitration. Well, the arbitrator sent a bill to the accounting firm, said, well, there's a filing fee. And for you, accounting firm, it's $1,500. For the person bringing the suit, the accountant, it's only $500. Well, there's a provision in the arbitration agreement that merely said to be shared equally, and the accounting firm took the position, well, we're not going to pay more than half. Well, since they didn't pay, the court said arbitration did not apply. They were going to court. Workers' comp. There's a bunch of workers' comp I have, and if you look through the cases, I'm not even showing slides on all the cases, but two I wanted to mention. This was an individual in Birmingham who was in Birmingham in a poorer part of town in Birmingham. There were boarded up houses no one was living in. He went behind the house to clean and mow the grass. There were multiple gunshots, went behind the house, and the individual was deceased. Well, believe it or not, in Alabama, it takes more than being on the job and being killed and murdered on the job while and to recover workers' compensation, not unemployment. Let's see. This is another thing. He was an individual 68 years old, and the court upheld total and permanent disability under workers' comp, even though they were their age. There have been people in Alabama still operating and recovering money under workers' comp who are 78 years old in Alabama. That's how poorly written our work comp law is. So we'll probably see more to come on that. Some of you are old enough to remember years ago that plaintiffs and lawyers tried to figure out a way to get around workers' comp. Workers' comp is called, it's an exclusive remedy, meaning that if somebody's injured on the job, their exclusive remedy is under workers' comp. The plaintiffs' lawyers found a way for a while to sue an individual supervisor for what occurred. It was called co-employee suits. They passed an amendment to our workers' comp law, and it became very difficult to next to impossible to bring these co-employee suits. Well, we're seeing those come up again. So far, they haven't succeeded, but I bet we will see more of those. There was a challenge against Governor Kay Ivey in one of her orders that she issued. The court, fortunately, again, held in favor of Kay Ivey and her authority to issue these public health emergencies and states of emergency. Here was an individual mentally ill in Montgomery, was put in a hospital in Troy because there was no room in Montgomery, and there was a recommendation the individual be committed. And again, right now, people are being committed while in a hospital, and they are having to wait to get into a state mental institution. And that's basically what this order said, is this individual would stay in Troy, although they were from Montgomery, until they could get into, and the patient found an attorney and then tried to challenge that. Well, at this point, at least, they were unsuccessful when you have to transfer someone else to another county because there is no room. This was kind of an interesting case. Non-competition agreements. Some of you may use these in some of your employment agreements. I hope not physicians, but other employees, executives, and other. It's kind of an interesting case. They did not say anything in the agreement about whether it continued past death. And the court ruled that because they didn't say whether or not the non-comp agreement continued past death, it continued past death, believe it or not. Kind of interesting. This is a little bit of a scary case. Again, a lot of you have agreements that you will sign, and a part of that agreement, one party or the other agrees to indemnify and provide liability insurance as a part of the agreement. And this was a situation where the steel company had a contract with a staffing company that was going to manage students coming to the steel company. A student came and a student died as a result of an accident on the job. And the company settled and others settled, and then the company sought to enforce the indemnity provision and the liability insurance provision against the staffing company. The Alabama Supreme Court said that was void as against public policy, at least in that situation. Lastly, I think we're seeing a lot of politicians making statements like this. You know, I say it one way today, I may say it another tomorrow. Who knows what they may say? I don't. All right.